Hello everyone, welcome to Apurva's Legal Bites. Upon the request of my subscribers, today's topic is on parole. It is an important aspect of criminal justice system. The term parole has been derived from this French word which means I give my word, means a word of honor. Since it has its origin in military law, it has been used by the prisoners of war for their release by giving a promise to return to the captor. Okay, in simple terms, parole refers to a prisoner's temporary or permanent release before the expiry or completion of his sentence on a ground of good behavior. This concept of parole is based on reformative theory. We can say that parole is a kind of consideration granted to a prisoner in order to assist him in reintegrating into a society. Means it is a tool for prisoners' social rehabilitation. And here you should know who is a parolee. A person to whom parole has been granted or a person who has been released on parole is called as parolee. Okay, and you should also remember that parole may be granted subjected to certain conditions, and if these conditions are not abided by the prisoner, means the parolee, he may be returned to serve his remaining sentence in a prison. And there are many cases where the courts have defined parole. For example, in Krishan versus Union of India, according to Indian judiciary, parole is a penological innovation and it is a success in rehabilitation and reducing recidivism. Okay, now the concept of parole has been established in a case Buddhi versus State of Rajasthan. In this case, the court held that the parole serves three purposes. First, it will be like a motivator for the prison inmates to change their ways. Second, it ensures that the prisoner's family relationships are as intact as possible, as they may be prone to fracture as a result of prisoner's protracted confinement. And third, it will assist the prisoner in gradually assimilating into society and adapting to its folds. Okay, now section 432 of CrPC. It talks about suspension and remission of sentences. So according to this section, the appropriate government may suspend the execution of sentence or may remit the sentence which has been imposed on the prisoner subjected to certain conditions or without any conditions. And here the appropriate government may either central or state government. Okay, now the question arises, does CrPC cover the concept of parole? So here you need to cite a case law, that is Sunil Fulchand Shah versus Union of India, where the Supreme Court observed that parole does not amount to suspension of sentence. So with this it is clear that parole is not covered under section 432 of CrPC. Now there are two kinds of parole, regular parole and custody or emergency parole. Depending on the situation, either of the parole will be granted to a prisoner. Now we'll see what are the situations under which the parole could be granted. When a prisoner's family member has died or when they are seriously ill, in case of delivery of the prisoner's wife, and when there is a threat or damage to the life or property related to prisoner, and for maintaining social and family ties, and when the prisoner's health is not well, and in case of marriage of prisoner himself or any of his related family members like son, daughter, brother, sister, and for any other sufficient cause. So when there are these kind of situations, the parole may be granted to the prisoner. But however, there are some convicts who are not eligible for being released on parole, like the prisoners who have been convicted of multiple offences like murder and rape, especially against children, and a prisoner who is not an Indian citizen, and the prisoners whose presence is considered to be a threat to national security, and a prisoner who has been involved in criminal offences against the state. Now, the matters relating to prisons comes under state list, means list 2 of our Indian constitution. So the competent authority to make rules in this respect is state government. And when a question arises whether a person should be granted parole or not depends on the rules and the guidelines of a concerned state. And you all knew that each state have their own rules. So these rules relating to prison will also differ from state to state. So I like to conclude that parole is not an absolute right. It will be granted after considering various factors like the rules of a particular state, the conduct of the prisoner, the offence committed by him, and its severity, etc. Because there should be a balance while ensuring the rights of the prison inmates and protecting the public from further harm. Okay, so this is the end of the topic. If you like, please like, share, subscribe to my channel Apurva's Legal Bites.